Welcome to Secretarial Practice Class 8. We have already completed first chapter. So, today we are going to move on to second chapter. Second chapter deals with promotion of company and secretarial duties. Okay. So, the first, what do you mean by company? So before going to promotion of company and secretarial duties, so we should know what is company, what are its features, what are the types of companies and all. So what do you mean by company? So it is said that a company is an artificial person created by law. It is a voluntary association of individuals for profits. We call company as artificial person created by law. So though it doesn't have its existence like a natural person, so it is going to perform its day-to-day activities, it is going to sign the contracts. So we call company as the artificial person. So this point, artificial person, will clearly understand while studying the features of company. So it secondly says that it is a voluntary association of individuals for profits. So what is association? A group of individuals, we call it as association. So here a group of individuals voluntarily, which means there is no force here. So voluntarily a group of individuals register under the Companies Act. So why they are going to get it registered? So in order to carry out some business, and whatever business they are going to carry out, so that business should be the legal business, and the main motive is to earn the profit. So here when we say a legal business, to become a legal business it should be registered, right? It should be registered. So or we can say company means to promote the art, to promote the science, to promote the charity, religion, sports, etc. So this is the meaning of company. Then the second is the definition. So the definition says that a company, according to section 3A subsection I of the Companies Act, a company means a company formed and registered under this act, or an existing company, we call it as a company. So you may ask, but when it comes to the term called as this act, we may say a Company Act 1956, or we may say it is a Company Act 2013. So what is this existing company? So it is said that a company formed and registered under any of the previous company laws is called as existing company. So if the company is formed under the Act of Companies or the Companies Act 2013 or 1956 or the existing laws of the company, we call it as a company. So next we'll move to features of company. So the first feature says incorporated association. What is incorporated? Incorporated means formed into a legal corporation, we call it as incorporation, right? So incorporated. So then association. Association means a group of person or a group of individuals. So here a company is required to be registered under the Act 2013 or any other previous company act. An association of person that is not registered is called as is not called as company. So which mean it should be registered. To be called as a legal entity, it should be registered under the act. Which act is governing the company? The Companies Act is governing the company. So it should be registered under 2013 Act, or it may be the previous acts, right? and it is compulsory for the Indian company so that it should get registered. And when it is going to come into existence, it come into existence from the date it is mentioned in the certificate of incorporation. So whenever you are going to get the certificate of incorporation and the date what is mentioned in the incorporated or certificate of incorporation, so that is the date from when you are going to start your business or when you are going to get it registered. So suppose you are going to get incorporated, there are some restrictions. So there should be minimum group of individual. When we say association, which means the group of persons should be there, association of persons should be there. Suppose it is a banking, so the minimum member should be 10, and for business then it should be more than 20, otherwise it will be treated as illegal association, right? It is treated as illegal association. Then the next is artificial judicial person, or we call company as an artificial person. As I have said you in the meaning itself, I am going to explain clearly in the feature. So this point speaks about a artificial person. We are going to treat company as artificial person. A company is an artificial person in the eyes of law. Why it is called as artificial person in the eyes of law? Because the company is created by the law itself, right? So a company is artificial person created by law but depending upon natural person. So who are those natural person? So such as shareholders, such as directors, officers, etc. So what they do for its day-to-day functioning. So the company as artificial person depends upon the natural person. So it is called as artificial person but not natural person. Why? So it is not going to fall ill, it is not going to die, it is not going to or it cannot be declared as insolvent. So it is the artificial person but not a fictitious person. So we call it as fictitious person. Why it is not a fictitious person? So though it has no body, no conscience, still it is exists, or still it exists as a person. So it can enter into the legal contract in its own name. So we call it as a artificial person but not the fictitious person. So what do you mean by fictitious person? False person. So it is not the false person, right? Because it is going to enter into some contract. So here it is recognized by the law or it is created by the law. So we call it as artificial person creating by the law but depending upon the natural person. The next is common seal. So being an artificial person, company can enter into contract but cannot sign the document itself. So hence it uses a common seal on which its name is there, right? So nowadays sign of two directors are used to bind company into the legal agreement. So what does it mean? Common seal. We being a natural person, so we are going to sign the contract, right? So now the company is an artificial person and a company cannot sign by its name. So it is an artificial person, it do not have any physical features like a natural person. So that is, it cannot sign its name. So the company must have a common seal, and this seal is affixed on all the important contracts, documents, papers, etc. So nowadays what happens, not only the common seal, along with the common seals they are going to have, or the contracts or any legal agreement, so it will be having a signature of two directors, so to prove that it is a legal agreement. So then the next is perpetual succession or perpetual success. So what is perpetual? Perpetual means it is not going to end or it is continuous. So company enjoys long and stable life. So it is not depending upon the life of its member. So it is said people will come, people will go, but I remain forever. So as I told you, artificial person, as an artificial person it is going to function. So it is not a natural person, so it is not going to fall ill or die. So perpetual, so we call it as never ending or continuous. So the people who are working, so people who are going to own it may change, right? So people may come, people may go, I remain forever. So, unlike partnership, the existence of the company is not affected by insolvency, lunacy, or retirement of its members or directors, which mean the life of company is not depending upon the members and directors. So, this is because the company enjoys a separate legal existence from its members. So though it is created by law depending upon the natural person, so when it is depending upon the natural person, it doesn't mean that the life of the company is depending upon the members or the owners or the the shareholders or the directors. So here it depends upon the natural person only for its functioning. Okay, so here it is said that the members may come, members may go, but the company goes forever. It is created by law and it is dissolved by law itself. So, suppose the company is going to dissolve, it is done by the law itself and not by the owners, members, or the directors. The next is limited liability of members. The liability of members is limited to their share capital. Liability of shareholders may arise to the extent of unpaid amount on share capital. So in case the fund and a fund are insufficient to pay the outside liabilities, but the liability of company is unlimited, company need to sell off all its assets on winding up of company. What does it mean? So liability of its members are limited to the liabilities of members depending on the face value of the share held by them. So what share you have in the company, so based on how much share capital you are going to hold in that company, so only based on that your liability is fixed. Okay, so suppose the company is going to incur the loss. Okay, so you are not going to bear the whole loss, right? So whatever share you have, so to that extent only you are going to bear the loss. So here limited liability. The next is transferability of shares. Shares of the company can be transferred from person to person, and this right is given by the Company Act itself. So whatever shares you are going to hold, once you are going to hold the share, you are being the owner of the company. So here you can transfer this share to someone else, or you can transfer the ownership, and this permission or this right is given to you by the Company Act. The members of public limited company can sell their shares without the prior consent of the shareholders. In case of private company, there are restrictions to transfer of share to other than members. Separate legal entity. Company has independent legal status different from its members. Suppose the creditor wants to recover their money. They recover from the company and not from its property, right? So like management is different from members. Company has a separate legal entity from its members. So members cannot held liable for the operation conducted by the company. Company can on its own enter into contracts for the welfare of the owners. So shareholders who are there, so for their benefit or for their welfare they are going to enter into the contract. And if anything happens, or suppose the creditor wants to recover, so they are going to recover it from the company and not from the property. Then the next, separation of ownership from management, or owners and managers are a separate person. So in this type of legal entity, owners and management are separate person. Management includes board of directors, chairman, CEO, which manages the company on behalf of the owners. The owners and management are separate. A large number of shareholders do not take an active part in day-to-day business or the management. So instead they are going to elect their own representatives, so known as the directors who control the company. Separate property. Assets of the company and the shareholders are separate. It has the capability of owning property, borrowing money, etc. Owners cannot have a right to claim any asset of the company, but they can have a right to claim their capital back. So, when we say I am the owner of a particular house or a property, so whatever is there in the house, so it belongs to me, right? So this is not the same in the company. So I cannot say whatever assets are there in the company, so that is mine, so I am going to take it back. No. So I can take only the capital what I have invested, but not the property. So you can claim only the capital back at the time of winding up of the company. So that too after paying it to all the outsiders liabilities like bank loans, secured loans, creditors, etc. and also to the preferential shareholders. The next is the large membership. So membership. So for the public company we don't have any limit, but the membership in the private company is limited to only 50. So citizen. So company is not a citizen. So company is a legal person, quite different from its members, but do not have a citizenship. So as we have the citizenship, company do not have the citizenship.